participating economies with 20 economies observing the work. Their scope that's set out on this table is really focused on operations and setting AI model standards that outline frameworks and principles to ensure model safety, as well as key AI principles such as trustworthiness, privacy, and ethics, and fundamentals like data and ensuring data is appropriately processed and used in AI systems, and governance and risk management. So they've published 17 standards, and an additional 30 are in the works. And the ones that they've published include standards on things like vocabulary, concepts, and terminology for AI. So those really foundational standards that ensure that when we talk about AI, we mean the same thing, as well as guidance on key issues like big data reference architecture, risk management for AI, trustworthiness, ethical and societal concerns, and computational approaches for AI systems, and other things as well. So just one example of the work that they are doing is this standard, which is a framework for artificial intelligence systems using machine learning. It provides a framework for the description of AI systems that use machine learning, establishing a common terminology and common set of concepts for those systems. And it really helps guarantee that AI systems that use machine learning that are created to the standard are created and run in an ethical, open and secure manner, and that they respect the needs and rights of the parties involved. And one application that we've seen for this standard is in healthcare, where AI systems are used to diagnose and treat patients, where the standard is being used and adopted by systems developers to help to ensure that their systems protect patient privacy and security, and to guard against medical diagnosis and treatment errors. And now that I've spoken briefly on what's already on the market, just quickly on what's on the horizon. I mentioned that 30 standards are under development by Subcommittee 42, and one key one that I thought I would highlight is the Artificial Intelligence Management Systems Standard, which sets out a framework of good practice for an organization utilizing AI systems or solutions. It's anticipated that this standard will be able to be used in conjunction with management systems for privacy and information security standards to provide a pathway to certification of AI systems in a similar way to other management system standards such as ISO 9001 that's used to certify quality management, or ISO 27001, which relates to cybersecurity management. And there's quite a lot of, I think, excitement's the right word, perhaps, in the standards world, because it's expected that this standard will have a similar impact to ISO 9001 and 27001, which are some of the most in use and most certified to standards internationally. So now moving back to one of the core questions for the panel, which was what opportunities exist for regulatory cooperation and standards development between members and stakeholders in the area of emerging digital technologies. And I've got quite a simple answer, and that is leverage the international work, use international standards to underpin regulation where that makes sense. And I think it's summarized by don't reinvent the wheel. All business stakeholders that I speak to agree that regulatory approaches for AI should be developed and applied in a non-discriminatory manner while taking into account applicable international standards and norms to avoid adding new or unnecessary conflicting rules on top of existing legislation. So as I mentioned, the catalogue of international AI standards is growing with some pivotal publications in the pipeline, and regulators and policymakers should carefully consider how standards can be used and for what purposes. So in addition to that, to pick up on a point that Humera mentioned on having a voice in regulatory setting, I'd also suggest that businesses, regulators and policymakers should also consider how they can have a voice in international standards development through their national standards bodies to ensure that their views and regulatory considerations are taken into account in standards development. And another opportunity is in seeking to engage and use the outcomes of other international and regional initiatives that set guidelines and principles for the development and use of emerging tech. One example of this is the opportunity in APEC, where there's a range of APEC projects currently running that are focused on AI or expanding digital and services trade in the APEC region. Two of them that I'm aware of is one which is supporting a study and workshops on how international standards can support responsible AI development and deployment, and another that is focused on building greater integration in services and digital trade through providing guidance on building strong and effective disciplines on services trade. And then just on my final slide, another opportunity is for regulators, policymakers, and businesses to engage with efforts to uplift standards awareness and adoption. One such effort that Standards Australia is engaged in is a newly established responsible AI network that is a cross ecosystem collaboration between Australia's key government research organisation and a range of AI thought leaders in Australia that has been established to upskill and prepare organisations to support them to adapt to the shifting AI standards and regulatory landscape. Now, while that's got an Australian focus, it also that a key part of the RAIN network is the want to partner internationally, and the work that they're doing is includes providing guidance through workshops and materials to support uptake and adoption of new standards. And while this is an Australian example, I should also say that this isn't unique to Australia, and there are many similar efforts to provide guidance on AI standards, the landscape and which standards are available to support policy responses and to support business. So I guess my last point would be to encourage anyone to reach out and to get involved where they're interested. Thank you.
Well, thank you very much, Jesse, and thank you for joining us from so far away. Much appreciated, as well to the other speakers who've joined us from different time zones. We're very much appreciative of you sharing your insights. I think we've had a very good overview, different perspectives from the private sector, from sort of research and analysis groups, from our government's regulatory side, and from standards organizations here, talking both about challenges and opportunities for trade in these intangible digital products. We've touched a little bit upon sort of some questions around definition and looking at what impacts of these regulatory interventions are, particularly on MSMEs, but also how there's an impact on sort of large multinationals, and contrasted that. And so I think sort of as a group here, now we've got an opportunity to talk about sort of regulatory cooperation. We've got an opportunity to talk about how we avoid the risk that has seemed to gone through all of the different presentations that we've had, about the risks of regulatory fragmentation. So at this point, what I'd like to do is open up the floor for some questions from any members, and please feel free to ask them of any of our panelists. Our colleagues who are joining us on hybrid should be available here. Yes, I'll open it to the floor. I also have some back pocket questions I have after all of those presentations, particularly about this risk of sort of addiction to my fridge, which may be something I have to worry about now. So please, if you want to put in your questions, I believe you can put them in through the Zoom chat. If you are joining from online, or please, members from the floor here. How to identify who's asking a question. Okay. Devin from the Secretariat.
Thank you. So maybe just to get the ball rolling, a question on my mind is I'd be very interested to hear the panel's views on the relevance of the TBT 6 principles, especially for regulation of AI. We know that, for example, in the G7 context, the 6 principles have been referenced in different documents on digital trade principles. So just maybe that would be an interesting I'd be very interested to hear the panel's views on the role of the 6 principles in this space for facilitating regulatory cooperation. Thank you.
Thank you. Panelists, would somebody like to take that one on first? Aitor or Rebecca, would you like to jump in on that one?
I'm happy to jump in and open this. Thank you very much for your question. I think, yeah, the TBT principles are mostly important when we think, of course, about like how we can improve international interoperability and ensure. So I think how they feature in how we thought about our approach is that, of course, when we refer to technical standards, for example, in AI regulation, how they can support the domestic implementation, but also increase international interoperability, we're always talking about international technical standards. So we tend to refer to those developed in ISO and IEC, for example, and or IEEE and other organizations, but standards that can be adopted by different countries around the world. And I think like the main potential for collaboration there is that the you know, like we have like different regulatory frameworks, like they might take different formats, for example, but at the end of the day, we're always trying to achieve like the same objectives in the sense of ensuring, for example, human-centric values are reflected in AI development and deployment. And these objectives we tend to see reflected as well in the development of international standards addressing these issues. So the presentation from a colleague from Australia was like really good to like outline, for example, some of the key topics that are being addressed by international and technical standards. Will include things such as bias mitigation, for example, and transparency, and like more the horizontal topic at this stage of AI risk management, for example, and AI quality. So I think there's an opportunity there for different countries to refer to like the same international technical standards, for example, and make sure that like we have like a common set of like principles, for example, and tools to adhere to those in order to increase market access. And the second one that I also wanted to refer is also the principle of openness and making sure that like these systems are inclusive, because we spoke a little about the limitations of technical standards and of course like the fact that they're going to take time to develop, for example, but once we get there, it's very important that they reflect the views of multiple stakeholders. It's not just the view of industry, for example, or like specific companies within industry. So a lot of the thinking that we're doing domestically in the UK, but also with international partners, for example, in the G7, is also thinking about how we can increase that inclusiveness of the process. So how do we make sure that these processes are also available for people across SMEs, for example, to access those who might not have the same, you know, like resources or like time or even like people to send to these processes. And it's with that in mind that we launch initiatives such as the AI Standards Hub to like kind of open up that process, not just domestically, but also to international partners who might be interested in this. And similarly, we also recently published the a portfolio of AI assurance techniques, which outline some use cases of like key assurance techniques such as impact assessments, for example, or audit that have been used by partners internationally to adhere to specific AI principles. And I think it's by building these like common tools of interoperability that we can increase market access and like think about where convergence at the implementation level, at least if it's not like a perfect convergence of like regulatory models, for example, can happen. But I'll stop there.
Thank you. Aitor, do you want to answer? I know Heidi wants to jump in as well.
Maybe just very briefly, because I have very little to add, but I think the most challenging principle to apply here is effectiveness. And that's where I think the dialogues should be very much reinforced, because what do we want to achieve and what kind of measures we want to have in order to achieve that objective is something that may diverge a lot from one jurisdiction to another. And this is, I think this is an area where regulatory dialogue would be extremely important. How do we want to, I mean, in some areas we will, there's nothing to do. We just have different views and those different views will stay there. So there's no way to find a common ground on those areas. But in many situations, there is a lot that we can discuss in order to find that common ground, to see that we actually share objectives and that we are approaching that objective from a different point of view, and that you can have effective responses to that objective that you can coordinate in advance.
Thank you. Edie, you wanted to jump in on that? And Jason after?
Very shortly. I would like to join also to what Rebecca said. I mean, in general, I mean, we need in these times where everything we are looking for, we are worried, we are looking for answers how to address these huge digital challenges. It's really good that we have principles to stand on and we can continue to use. And here I think that the words of collaboration and transparency are really important, and we should not forget that in our efforts. Thank you.
Absolutely. And I think that was something that came from other speakers from the private sector. So I'll pass to Jason.
So thank you. I also want to recognize that there is a diversity of standardization underway, and we certainly greatly endorse what's happening at ISO/IEC, but recognize that there are going to be a number of different efforts. And I want to underscore then the importance of the concept of coherence, and that the fact is that one of the methods that we'll get there is to not try and standardize ethics. That in fact, recognizing the diversity of ethics across the world are one thing, but the underlying practices and engineering mechanisms, management systems that can be articulated, such as via the ISO/IEC standards that are being worked on currently, are a way to establish a set of coherent concepts that then can be applied in any market with the ethical overview and the legal structures that might exist within those countries. And so I would really emphasize an importance of this concept of the coherence, and to recognize that I think there is a path forward where we can have internationalized, harmonized approaches that are coherent with the different ethical and legal structures around the world. Thanks.
Thank you. And I see the UK.
Sure, thank you. I would like first to thank all the presenters. We found their presentations really interesting and really like to see the recurring themes of collaboration, international standards, and adaptability and flexibility. I guess a question I had for everyone really is thinking about the current state of play and the fact that regulations and international standards take a long time to be developed. What could be interim solutions, and how quick do you think the current systems can adapt to the sort of agile pace at which technology develops? Thank you.
Jason.
Sorry, don't mean to be overwhelming the conversation. I think it's a wonderful question. I think one of the things that we've often heard is that, well, standards are so slow, but standards move quicker than law, but innovation moves quicker than standards. And so how do you deal with that set of relationships? I will point out that the work at ISO/IEC SC42 began 4 years ago, and that ultimately you have now a significant number of documents that are already completed. But then more importantly, the management system, which is coming, I think is going to be that critical next step, and that's due to be published in the fall. It will still take time for a certification regime to be built around that. It won't happen overnight. I think that one of the dynamics is in having as open a view to having interim steps as well as long-term steps, and being comfortable with the fact that that's going to have to evolve over time. So thank you. I'll stop there.
Just a reminder, I encourage people to members to submit questions online. So maybe I'll jump on that one, not seeing anybody from inside the room. No. So I think since definition seems to be a fundamental departing point to address regulatory fragmentation, I'm wondering what panelists thinks can be done. We've talked about sort of ISO having a definition. Can we have a global sort of single approach for an AI definition? Do you think that this is feasible?
Well, that's a good question. I hope I could have an answer. I think that much of the digital innovation is difficult to put in one box, and something what when I listen to the discussion here, I mean, we feel at ease when we can put our let's say regulatory framework in different boxes, products, services. We define this. What brought me in thinking, doing also this study, was that we cannot maybe use the same boxes anymore, and we need this overreaching collaboration. So what I hear many times when I discuss innovation with companies, it depends, and you have to look really where AI is used. So it would be fantastic to have one definition, one model, but I think that might not be possible. We can, however, have international guidance.
So I'll just point out that one of the first steps in any standardization exercise is terminology. It's one of the foundational pieces that always gets done. And there certainly was quite a bit of work around the principles. There are probably dozens of different principles documents out there. The OECD's document was one of the most influential, but certainly not the only one out there. And there was a definitional effort there. But ISO IEC, if you would care for the number, is I believe it is ISO IEC 22989 is a standard that is about terminology and reference and it is concepts and terminology. But the point is that is referenceable by any regulatory effort, and it is something that 104 countries did in fact vote on. So the experts from the countries were working in collaboration to attempt to get to a harmonized definition.
Francis, I don't know if you can hear us online here. I think we're raising hands, but I don't think you can see us. So I'll just make a quick comment to your question. I think the need, there's definitely a need to reach a consensus for the definition for AI, because we're dealing, and specifically talking about AI, is because it would be, the global definition would at least help us to ensure that AI is used in a responsible and ethical way. I think that's the biggest concern we're dealing with. But I also think there needs to be some flexibility, because the regulations usually don't imply that kind of flexibility. So we need to look at maybe some sort of a regulatory sandbox approach, so that we can look at how we can accommodate the different ways AI is being used around the world, and then the different levels of technological development that's happening, and how do you at different levels start to implement certain kinds of regulations. Once agreeing on the definitions, and then how do you start to apply certain kind of regulations, I think that is what is required for us to take that kind of a flexible approach, and that's why I called it the sandbox regulatory approach. I think that's how I would think about it.
Thank you. That's very interesting, Humira. I see, Rebecca, you've got your hand up. And also, Humira, thank you for reminding me to look at the screen to see if your hands are up. Rebecca?
Thank you very much, Francis. And at this point, is just to echo really what has been said by colleagues just now. But I think one thing to mention is that to agree with what Jason just said, there is an increasing movement I see towards convergence, at least on AI definitions. So, and just to cite the OECD work that has been done recently on updating the definition, for example, but also make sure that it aligns with the definition that has been used, for example, in the NIST AI risk management framework in the US, which is also based on the definitions that are being used in technical standards, for example, and it's also aligned with the definition that is being used in the most recent draft of the EU AI Act, for example. So I think we're seeing a movement for these definitions to align at the global level. I think the challenge that we recognize on our side, for example, and that's why we decided to use the definition based on the two characteristics of AI rather than have a one-off definition, is that of course it will be challenging to update the definition as the technology develops. It's really hard to come up with a definition initially that is at the same time narrow and general enough to like take into account basically the future developments that the technology might take, and also ensure that it doesn't capture things that are not necessarily AI. And I think that is why like processes such as the OECD that like bring together different partners to discuss these things are so important. But I think we still need to recognize the challenge that even if we have a definition, it doesn't mean that that will be it. I think the main nut to crack basically is to understand how we can have a process in place to update these definitions in a flexible enough way in order to keep up to date with how the technology develops, especially as this definition starts being integrated into legislative processes, for example, because that is effectively like moving slower, for example, than the technology, and might hinder innovation if there's uncertainty because the definitions are being updated, for example, and people don't know what the regulation applied to. But I'll just stop there and just basically to mention like the importance of the international work in this space.
Many thanks, Rebecca. I think the United States, please.
Thank you. And this question is for Canada, UK. You know, the EU has notified its EU AI Act, and I think from our perspective, that was really helpful in the sense that we got you know, an ability to provide a good notice, a good comment on what was notified. In the framework setting that Canada and UK have, is there any consideration of notifying the TBT committee of information if it's not a technical regulation, just given the interest of the committee in the subject? Thank you.
Maybe I'll turn to Rebecca first.
Sorry, could you repeat the question? Just my laptop was having a little breakdown.
Sure. My question, well, I made a statement. I said the EU notified the AI Act, and I know several of us as members commented through the WTO TBT notification process, and that was really helpful in our minds to be able to see what the EU was doing. In the framework setting that the UK and Canada have, has there been any consideration of making a notification to the TBT committee? I know that you might not have a regulation, but it might be something that you could consider to notify as an other if you're not having a formal technical regulation, but for information, since this is such an important topic to the committee.
Thank you very much. Yes, I think that's one that I'll probably need to take offline. But in general, like just as part, we're again like starting with an iterative approach, as I mentioned. So at the moment, we don't have like legislation, for example, like specific to AI, but instead we have like these principles that regulators will implement to complement existing regulation law and clarify how AI principles apply in the remit, for example. We said at the beginning that depending on how the technology evolves, for example, and evidence that we gather through the horizon scanning functions, for example, and working together with stakeholders, there might be future interventions that we might need to consider in order to address AI risks effectively. So I think it will depend, like what we do will depend on like where we get to in that stage. At the moment, we're still like iterating and like considering if anything else is needed, like how effective the approach is currently being, and again, prioritizing international actions for common challenges that we see through initiatives such as the summit. But yes, I'll take that offline, and I'll just need to, it's not really my policy area, so I'll need to like talk with a few colleagues who are closer to that process.
And I guess I mean, maybe I should turn to the Canadian delegation instead of me as moderator, but I don't know what your preference. I can answer Francis, or you can have Francis answer. We're very uniform in our names. It works.
Francis, you can answer.
Merci bien. I mean, similarly, we're putting in place a broad framework for requirements governing artificial intelligence. And that the intention there is that would allow for consultation with stakeholders, including other jurisdictions. Following those consultations, then we'll start putting into regulatory measures outlining the types of AI systems that would be regulated and the requirements these systems would need to meet. And so those regulatory measures would be where we would be intending to notify.
Thank you both for your answers. Thank you.
I saw a hand up from ISO.
Thank you. Hi, everyone. Thank you for the wonderful presentations and good to see you, Jesse. So my question was here more about a point that most of you raised, the need for capacity building. I wanted to ask you if you could explain a bit more in terms of what kind of capacity building would be helpful to ensure regulatory cooperation and convergence. Thank you.
Maybe, can I put that to Humera? Would you be interested in responding to that?
Sure.
Capacity building?
So capacity building is about actually a few different areas. One is capacity building around taking it beyond a small group of people and raising awareness about the different kind of regulations around the AI side. So how do we have enough of an outreach so more and more of companies like us and others can have an understanding? And so what kind of capacity can be provided there? The other part of capacity building is around the technical expertise. How can the regulatory side can help so that more and more people can understand the risks and benefits of AI technologies? And so this is really where technical expertise is required. I also believe that there is an ethical expertise required around capacity building so that those kind of expertise can help people provide a framework around what do we mean when we talk about ethical framework. Legal expertise is required, policy expertise is required. So I think there is capacity building around different areas, which is required in order to make people aware and then being able to implement these kind of regulations. That's how I was thinking about some of the capacity building.
Thank you, Humera. And I think this relates well back to sort of what the original question where we were talking about the principles. As development dimension is one of the principles. We've had a very sort of developed sort of country perspective here. And so it would be interesting to hear from members from the developing world and sort of feeding into the Secretariat in terms of what steps we can take as a global members and to sort of address that area as well. I don't know if anybody wants to speak to that. I don't see any hands up. Maybe I'll leave it as a statement.
Yes, thank you. I'll take the opportunity of the silence to jump in and like to make a comment and maybe pose a question related to my comment. There was the importance of transparency was mentioned and also the difficulties of maybe SMEs accessing relevant information. And this may also apply to developing countries who want to follow the evolving regulatory framework, but don't know how. And yesterday was sort of a longer day on transparency for the TBT delegates, but maybe especially for those who are not fully involved in those discussions. I'd just like to remind you of the Secretariat service called EPING, where you can actually, to the extent that members notify, also using member EPING, any interested entity, a government official or a private sector person can register and receive alerts as these notifications come in, and they come in usually with a comment period, so time is of the essence. So I'd just like to encourage those who may want to follow further this area, regulatory developments in this area and upcoming notifications to go ahead and register on EPING. And for those who are in the private sector, then they can liaise with also their relevant officials to take any issues forward. But just wanted to take opportunity to make reference to that website.
Many thanks. And actually, that does remind me a comment from yesterday from the EPING session. And in response to your question, Jennifer, we could consider notifying as other, but we'd have to take that conversation offline. So maybe I'll jump in with another question that I have, and this is because you touched on this, Heitor, because digital regulation entail non-typical risks, and other speakers have talked to this in terms of privacy, morality, societal values, and that are inherently less prone to harmonization. And they're very much more prone to sort of specific country and regions potentially. So this creates a higher chance of fragmentation. So as the TBT committee, what are things that we can nonetheless sort of do as a committee? So like the examples for more transparency, more committee debates, exchange of experience, more speaking to a private sector, voluntary guidance, just to frame it a little bit.
Thanks a lot. And so maybe before answering you, just to notice that in some areas, if you take the area of services, we have global operators on searchers, cloud computing, platforms in general, advertising, and national regulations, domestic regulations are completely different. So the fact that there is fragmentation in regulatory approaches does not necessarily mean that there is not going to be integrated operations with presence of SMEs, it makes it more difficult, of course. I mean, regulatory divergence makes it more difficult, and particularly to small and medium enterprises. That is true. But we have already the example of many areas that are not subject to the TBT agreement at all, and where you have different levels of commitments in the GATS. In some cases, you have no commitments at all in many countries, and still you have all these activities that are made in those countries. And in some areas, you have very strict, very strong commitments, but you still have important regulatory divergences. So what is new here is that this fragmented world comes through the digital technologies into products that before this digital revolution were not subject to this risk of regulatory fragmentation. That is what is new. And in order to address that, I think the most important is to first to exhaust what we already have, and it's very challenging and it inspires a lot to hear about the possible ways to improve standardization, etc. But we already have here in the WTO an instrument that can be quite powerful, which is the TBT notification system. And it's very nice to hear about EPING, because it's something that could be used more. I think it's very important first to really encourage, but more than encourage, to remind that there is an obligation to notify all kind of regulations that impose regulatory requirements in this respect. And that's something that should be done in good time, and that should give rise to the specific consultations that are needed to prevent, to the extent possible, the regulatory divergence that is going to make business more difficult. So I think it is very important to make the best use of what we already have, of the TBT committee, to notify everything, to give appropriate time for consultation, and then maybe to bring here to the TBT committee to not only experts in TBT measures, but also sectorial experts. This is going to be more and more needed, because we have little time in order to solve problems before they apply to the market, and you may need to have experts in that respect. So it might be needed to get used to have for this kind of regulatory measures, to have not only trade experts, but also regulatory experts, and also to involve upfront civil society in our jurisdictions, because some of the answers that you have to give, I mean, to assess whether it is possible to avoid regulatory divergence, you may need to have the views of your civil society before, because there are certain things that, as I said before, you don't want to avoid, because it's a legitimate concern that your jurisdiction has. And for that, you have to integrate upfront the views of the civil society.
Jason?
Yeah, no, thank you. Maybe, yeah, take the opportunity of being here on the podium with your indulgence to make a question, because I think Jason's, your example on turbines was quite interesting. I was just thinking, and then perhaps linking with Heitor's point on data and non-typical regulated aspects of these new digital products, that maybe in the old times you would have a turbine producing pollution that will be released by the turbine and being regulated. And now you have a turbine producing data that you want to regulate that is leaving the turbine as well, and then you want to regulate. So my question is this the data dilemma or challenge that you mentioned, that sometimes it can have an impact on data flows, which is normally a services topic, but now in this case, maybe linked to the product?
Well, I mean, the first thing is that data regulation is not new, and problems related to data fragmentation, I mean, regulatory fragmentation on data are not new. And still we have a data economy across the world that functions with its problems, etc., but that functions. So data regulation would also apply to machines that are connected to the internet. That is, I mean, you cannot have your data regulation and not apply this to machines that are collecting the data. So that is not possible. But you have to look at that when this, if you take the example of artificial intelligence, for instance, embedded in products, you will need to apply the principles of the TBT agreement. So there are certain things that you will need to do that maybe you are not looking at now. I'm not completely sure that the result will be different. So maybe the example of the turbine is I find difficult to see how, for instance, if you think about conformity assessment, how the conformity assessment on the machine will depend on your data regulation. But the sending of the data, which is not about the product itself, is about how you are going to collect information that has nothing to do with the product. I mean, the product has some functionalities that are important in order to collect data, in order to sell data, but the rules that apply to the sending of data or the collection of data, those rules will continue to apply the way they are applying now when you are using a purely service related technologies, like if you are collecting your data in a platform or through online advertising or in cloud computing. So there should be no difference in treatment of the same reality, just because what what makes the collection of data available is no longer a service, is a product.
So I'll put to you, Jason, data as a product.
So I want to thank you. It's a fascinating conversation. I want to step back. I believe it was a question from the United Kingdom from the floor about time comes back to this, and timing and the speed of things. And to Heitor's comment a moment ago, I think one of the challenges that we see is that as governments are trying to move faster, they're turning towards non-traditional standardization mechanisms. They're still multi-stakeholder groups. Sometimes they're called codes of conduct. Sometimes they're called just, I believe in Europe, there's a concept of the common specification, but there are other domains where they're moving to finding multi-stakeholder avenues to address these concerns at a higher rate of speed than maybe they perceive what the standardization system might provide, even within their own domestic system. And I think that even within those, the TBT, the remit of the 6 principles and of what the TBT is meant to protect should equally be applied, because the danger therein is the loss of the due process, the loss of the protection of the minority voice, the loss of protection against pro-competitive or competition law concerns. As people attempt to move faster, they tend to resist those strictures that are based upon the principles established under the TBT, and that presents a real challenge, because ultimately you end up with potentially some aberrant outcomes that can be really problematic for both small and large players alike. To the data flows conversation a moment ago, I guess the challenge that we see is that the reason I chose the jet engine or the refrigerator example is that those present scenarios where you have entirely new business models that are dependent upon the data being generated. So you still have the physical product, but if you establish that there might be entirely new industries that form around the service that is now being put forward. So for example, predictive maintenance AI systems that get sold into the aeronautical industry would suddenly be only possible based upon that data being available. And so that you have this inherent difference between what was traditional physical good suddenly creates an environment wherein you have entirely new business models. And as we go to seek, and my company has been very vocal on the idea that there needs to be regulation of these digital services and of digital technologies. We recognize the societal importance of what's being discussed. But please recognize that you're dealing with something that is inherently new and different than the environment that you've had before, where the TBT structures or the GATS agreement are based on certain concepts that were established at a time when these models didn't exist. And so now we have something new, and please modernize that approach relative to the newness of what's at play. So thank you.
Thanks, Jason. I fully agree that there is a new area of services and products that are generated by new technologies, but I'm not that sure that this is something completely new. If you take the example of the engine, that data economy is something that already exists, for instance, on online platforms. You have many online platforms that they are selling a service, and they are collecting data, and they are creating new services, new products, if you call them. So this is not new. This is something that already has been in place for at least, I don't know, 20 years or something like that. And what we cannot expect is that the legislation that has been adopted in order to address some challenges that these new, in this case, services pose to the society will not apply just because the data have been collected through products and not through services. The principles of the TBT agreement, the rules of the TBT agreement need to apply. And I think there is something very important, because we are looking at concepts that are relatively sophisticated, and we are trying to we are thinking about preventing ways to deal with legitimate regulatory concerns. But the scope for non-legitimate regulatory purposes is huge. And that is something that is maybe simpler, easier to address, and that the TBT committee is well placed to try to prevent. Because the potential for using regulatory measures in order to just impose purely protectionist requirements is huge. I mean, if you just impose something in your cybersecurity law that creates a huge disadvantage for foreign companies, and it does not serve any regulatory purpose that is legitimate, you are actually imposing a regulatory barrier that has the potential to extend across the whole economy. So that's why I think the transparency function of the WTO plays a fundamental role. We should have, I think, an inter pares push for an obligation for everyone to notify measures that can impose this kind of requirements, and have enough time in order to discuss them, to identify issues that are not truly regulatory concerns, and to try to address them before they create problems that would be very difficult to solve in the future.
I'll pass the floor to Humira to close off this question.
I'll keep it very short. I will agree with what Jason was saying earlier. I think we're dealing with something this is more of a nuance than something that we have dealt with before. And what we're really dealing with is not just data around data privacy now, because we're still at this level, we're talking about data privacy and regulations around this, but things are moving forward so fast, where now we're talking about who would own the IP from the works of that data at the end of the day. And that's really not even my own data, right? When I'm dealing with another layer of AI, which is generative AI, and new content is being generated just on the basis of the information I'm providing, now we're talking about IP for AI specifically as a specific category as well. So I think we are not dealing with what we have dealt with before. We're dealing with something which is creating a whole new industry, a whole new economy. And I think that's what we got to as regulators, anybody sitting here who are actually going to look at what the future would look like. This is a new economy we're going to deal with. So it's not just about regulating and making sure that everything is safe and ethical. It's about the nuance of how this kind of an approach now with what is happening in AI is creating a whole other way of doing business, where it's not just about no more boundaries are there for anything. So we would actually see a lot more IP infringement that's coming up, and hence why they're talking about creating IP for AI as a specific category. That's what I wanted to bring up, because I think this is not something that we have dealt with before.
Very, very, very interesting in terms of new models, new issues that are raising and things that are evolving. I know sort of a good example I was given was sort of moving from the horse and cart to the car. We still define the power of the car in horsepower. So we're also looking at brand new language as well. So something to think about. I see the United States up. And I did promise at the outset to allow our panelists to ask questions to each other. So I'm going to give a last call to the floor, first to the United States. This is the last chance, and then I'm going to let everybody go early once we've had a chance to hear from questions from the panelists.
Thank you. This is Jonathan McHale from the Computer and Communication Industry Association. Question for the EU and keying off the interesting jet engine issue. So jet engine, clearly a product. A rule affecting whether that product can move data either from the engine to the ground does open up this new area. One of the new measures that the EU is considering is the Data Act, I believe it's called. Moving away from just regulation of personal information to non-personal information. So under the Data Act, from what I understand, there will be a requirement that potentially restricts a company using a product from moving data outside of the EU. That certainly is a characteristic of the product. The product will have that functionality disabled in certain cases. So the question for the EU is would a measure, a instrument like the Data Act be notifiable? Should it be notified under the TBT? Because it does impose a restriction, certainly on. I don't think there's any ambiguity on a product and how the product is being used. Thank you.
Thanks a lot. I don't know whether the EU was me or I guess yes. I think we have to, I think it's a good example of what we have to distinguish here. Because one issue is what the product does, how the product needs to be tested, what the specifications related to data transfers this has. Is it cybersecure enough? Is it, for instance, in the union, you have the GDPR and you will have the Data Act. And of course, that regulation needs to be respected. The product in itself cannot breach the GDPR because the product doesn't do anything. The product just gives you the possibility to transfer data. How the data are transferred, this is something that has nothing to do with the product itself. It needs to do with the business model of the company. It has something to do with the business model of a service supplier that is relying on the company. It is not about the specification of the product. If you are asking how the product needs to have some cybersecurity requirements, that need to be high so that the data that are produced cannot be hacked, for instance, or cannot be accessed by anyone. That is something that relates to the specifications of the product. If it is about the product should not be able to steal data or to process data in secret, because that would be in breach of, I don't know, the GDPR or whatever, that is a specification of the product. But whether the company that owns the product, whether this company can transfer the data or not, that has nothing to do with the specifications of the product. This is a legislation that applies to the company, does not apply to the product. And it may change depending on different situations. It may change depending on, in the Data Act, I don't know whether you are familiar with its content. The European Union is not reproducing what it has done in the GDPR. So this is not about a system that prevents the transfer of data to third countries and only allows this under certain circumstances. What it does is it creates a number of obligations for companies that are using data, that are collecting data, that are transferring data to other companies as a business, as part of a business. It does that. And it also creates certain protections against, to put it in a simple way, against the violation of the confidentiality of the data or the access of data that are protected by law. So just to give you the example of this product, if this product is, you put the product in an airplane that belongs to you, and this product is stealing IP protected information, for instance, from the airplane, and is sending this to a third jurisdiction, that is forbidden by the Data Act. But that has nothing to do with the specifications, with the technical characteristics of the product. I don't know whether that solves your question, but I think it's important to differentiate what are product characteristics. These are subject to the TBT agreement. And what is not about product characteristics is what a company can do with the data that they own or that they generate. And in both areas, the union will not adopt and has not adopted any protectionist objective.
Thank you. And thank you, Heitor. Maybe I'll pass to the chair to ask a question.
Thank you very much. And thanks for extremely interesting and educative conversation. So I have a question on regulation. So how could the global level catch up as regulation is happening at national and regional level, or is it completely utopistic to think that these issues could be agreed upon at a global level? And in any case, the cooperation between the different organizations is very important, clearly. Thank you.
Not seeing any hands up to tackle that one online from the panel. Heidi?
Thank you. It's a really important question. And I think that, I mean, the basis of it all is knowledge, education, getting everybody on the same line. I mean, everything is happening so quickly. It's really difficult to follow all the trends. We have many good international forums, including the TBT committee, where we have the possibility to discuss and reflect over these issues. So I'm still hopeful, and we have a lot of competence in all the areas that are related to technical regulation and under the TBT chapeau. So I think that by joining our efforts together, increasing the knowledge, we can come quite far.
Thank you, Heidi. Rebecca?
Thank you very much. That's a very good question. And I think like there's a distinction to make between like the things that should be addressed domestically and like the things that can be addressed internationally. So I think whereas like, of course, like domestic approaches to AI regulation will depend on like the very specific like context of the country, the kind of like values, again, that are embedded in like their like cultural background, like what they are trying to achieve might differ like across different countries. I think it's important to identify what are the building blocks of regulatory approaches that can be found like in common and can serve as the basis for international agreement and guidelines, for example. So I discussed before like that we might see like divergence in approaches in terms of like, for example, taking a horizontal approach versus a sector-based approach that again will also depend on like the specific economic system that different countries have in their very specific region. But there are common building blocks, which will be like sharing things like principles, for example, in terms of like what are the key objectives that we're trying to regulate for. Could be things like the human-centric values, and I made the example before of like the OECD principles, for example, be reflected in the UK approach, but also across other regulatory approaches that we already see emerging. And then there's the additional side, which is also like there could be commonalities in the implementation of like these different regulatory approaches. So again, there's I think like opportunities for us to like collaborate on tools for trustworthy AI, for example, as like a tool to implement these principles, and that can have like common approaches such as the use of like international technical standards, for example, adherence and like specific techniques. For assurance, it could also be like agreeing on like a list, for example, of AI risks that countries need to be prioritizing in order to like move measures at a domestic level, but also the international level in order to address that. So I think there are definitely opportunities for something to happen internationally. And I think recent developments in technologies such as generative AI, general purpose AI, and the expanding focus on like future risks as well that are at the frontier of this technology represent common challenges that independently of the regulatory approach that has been taken by different countries are overarching and are like common challenges for like every single partner. So I think there are opportunities there to have internationally agreed on like guidelines, for example, and safety measures to agree on those. And that is also because one of the additional complications that like these technologies also offer is that of course they have a very complex value chain. So you can't necessarily control where the actors across the value chain of AI will be based. You have like, of course, like systems that, for example, are integrated, but are being like provided and built in a country, for example, integrated in a product that then is then offered in a different country. So because of all these issues, that is where international collaboration and agreed on guidelines are really needed. So I think there are opportunities, especially for like common challenges that we're all facing, but we might also like need to understand that at the domestic level, because of this particular context of a country and the regulatory environment and ecosystem, domestic approaches might diverge, but that doesn't mean that the general principles and like objectives and how we go about them in implementing them differ as well. So I think that's where the international agreement and collaboration should be looking at. And we're already seeing initiatives happening again in bodies like the G7 or like Tools for Trustworthy Collaboration, for example, OECD, that they're doing some work for the expert groups on international interoperability of AI risk management approaches, for example, and many other bodies. So that's where the focus should be for international collaboration.
Thank you very much, Rebecca. Anybody else from the panel who wants to take that? So as promised, I'm going to give the last questions to the panelists. If you'd like to ask any questions, throw your hands up if you're online. Here, I see Haiti up with her hand first, so she gets first to kick it.
Okay, I would like to pose my question to UK and Rebecca. I mean, I was really fascinated hearing about UK vision and principles on AI. Today, I think that we have really got the scope of showing the complexity of it. And I wonder how you have ended up in your current approach and your national strategy. And if you have difficulties in balance, I mean, between these various regulatory boxes or aspects, and for example, how to balance different, let's say, policy concerns, critical infrastructure, cyber in your policy. This is my one question. And the other follow-up is, we have mentioned the role of market surveillance that I think is getting more and more important in related to digital technologies. How have you approached the enforcement of product safety and security and market surveillance in your strategy? Thank you.
So I'll ask you to keep your answer brief, Rebecca, even though that's a very big question.
Yes, very long question. Thank you very much, Heidi. That's a really good question. And again, I'll try to be as brief as possible. So just to quickly speak about the process behind the development of our approach. It's been a long process that has spanned across 3 years, I think, recently. So it started with the development of the national AI strategy, where we identified what were the key actions, for example, that we needed to follow to remain a global superpower in science and technology. One of the pillars, as I mentioned in the presentation, was on governing AI effectively, but we also focus on making sure, for example, that we invest in the AI ecosystem, and that includes skills, for example, and ensuring that the benefits of AI are enjoyed across the economy as well. So investing in sectors as well for the application of AI, sectors that are usually sometimes not really targeted as potential sectors for growth, such as agriculture, etc. So we had a very big agenda of investments that have been made across these areas. But for regulation itself, it's been a very collaborative approach since the beginning. So what we did was to make sure that we had a process in place to speak to a wide range of stakeholders, again, across industry, like civil society, and very closely working with our regulators. So we started by doing an analysis, for example, of the existing regulatory landscape in the UK, understand what the particular areas of expertise and remits of specific regulators were, where existing regulation was enough, for example, and where we needed to be complemented by something else in order to address AI risks effectively. And that is because, again, we need to take into consideration that it's not moving in a vacuum, AI regulation. There are already and it's been mentioned before in this discussion, there are already very strong legislative frameworks, for example, that address specific aspects of it. So we have data protection frameworks, for example, in the UK and the EU. We have an online safety bill, and all of these already deal with specific harms, if you want, or risks of AI. But what we saw the need for was this overarching framework to set the expectations of what responsible AI development and deployment looked like in the UK. And that is why we decided on the principles-based approach. We published the policy paper, which had the initial emerging approach in terms of setting out our principles, for example, and the need to work with individual regulators back in July. And then we also published that together with a call for public views. So again, through stakeholder engagements, we refined these proposals that then resulted in the specific proposals that we had in the white paper back in March 2023. And that, for example, informed our decision to also have some sort of central coordination for the central functions that has then been implemented in the framework. And we will continue with this collaborative process. So again, we wanted to have something that is very flexible and can iterate as the technology develops, and also is very rooted in the existing expertise that we have in our UK regulatory system. So again, these principles will be implemented and complement existing law and regulation, for example, using the sector-specific regulators' expertise. I think there was a specific question also on market surveillance. So again, we are leaving it to specific regulators across different sectors to define, for example, what the principles will look like in the remit, and what practical measures stakeholders across industry, for example, will need to take to comply to them. So to give you an example, you asked about safety, for example, product safety. We have OPSS, which is our Office for Product Safety and Standards, is the regulator overseeing product safety in the UK. So they're going to be doing a review of what AI and machine learning, for example, means in the remit, what additional measures might be needed in addition to existing regulations to deal with these risks. And similarly, we have, for example, regulators like the MHRA, who oversee medical devices and how AI goes into that. And all these regulators across sectors are already starting engagements and projects to basically review what the implications of new emerging technologies such as generative AI are for their sectors and what else is needed. So in just summarize very shortly, collaboration and then reliance of existing framework and identifying gaps and filling those through the implementation of the principles. But I'll stop there.
Thank you so much, Rebecca. Last question to Jason.
Sure, thank you. So there are ideas out there. We're going to take AI just for a second and say many people are raising examples of AI where they can raise a question of when is it unethical not to deliver an AI solution, such as in healthcare or places where people don't have access to physicians, that there might be opportunities that AI brings to the market that are very different. And hearing from Humera's comments earlier and examples that I provided where it's really about opportunities from technology to create new business models or new opportunity in many different ways. So my question to the panel members really is, in speaking of standards, I've heard you refer to standards as a mechanism for technical regulation, but there's a fundamental other side to the conversation about standards as a voluntary market-led system designed to promote opportunity. So I'm curious from the panel, how do you differentiate between the role of standards for that voluntary market-led opportunity side as opposed to standards as a function of technical regulation?
Show of hands online, or someone want to take that on, or here?
Jason, I'll start. I can start some very with my thoughts around it, at least, is I think before we go down the path of regulations, I think first comes the guiding principles of any business. And I think this is really where we're losing sight. And even though AI is providing a lot of opportunity, we would need to apply the basic business principles to it first. It doesn't need regulators first. I think it needs the basic business principles first of where it's used, how secure is it, how safe it is for everybody to use. And then comes the specific things that we need to apply around AI is that it's not including any biases, that it's not actually causing any harm. Those are the second level of, I think, business ethics that need to be applied. I think those are some kind of, we don't need to be alarmed by a lot of AI at this point. I think we need to just calm down a little bit and start looking at what are the basic business principles, the different ISO certifications, everything that is required around any of the business and technologies, those need to be applied. And I think then the regulators in this case also need to take a different look at it, because just this morning, a big news about one of the top tech guys saying, let's remove the regulators from this cycle and let the tech guys drive the regulations for AI because the regulators don't understand it. I think any of the extremes won't work. I think regulations, working with the tech, working with the industry is what regulation around AI specifically should be, because we're dealing with something which is innovative, because we're dealing with something we don't know what are the boundaries around it. I think that's really where regulations need to come. But we need to look at it, is not go to the extreme and let tech drive it, not go to the extremes and let regulators drive it. I think we need to find a common ground. This is really what I as a tech person, I think about, how do we put all of the regulations together in one place and then start driving, okay, the things that Rebecca was talking about, start applying the different layers to it. And then you start driving, okay, these are the basic building blocks. Then these are the specific around, like the ethical part, the bias part, all of those. And then comes around a specific industry, then comes around specific regions. I think we need to start, that's how I would look at it, is basic business principles and then taking it applying different layers to it from an AI perspective. Because if one person leads this, the tech leads it or regulators lead it, it would be very hard to implement it.
I think you're landing us in a collaboration point, and I'd venture to add civil society in there as well. Maybe a little controversial, but I think it's worth sort of adding that dynamic. And maybe I don't see any other hands up. So I'm going to take this opportunity to close the session and release everybody to lunch, so that you will continue to like me in Canada more generally, because we are very nice. So I'd like to thank all of our speakers, those who came here in person and those who joined us at very odd hours of the day from far away, both for your presentations, your insights, your questions, really wonderful and quite in-depth discussion. I'd like to thank our participants for the insightful presentations, thought-provoking questions, and interventions. In my capacity as a moderator, I will be providing a brief report outlining a few personal conclusions on the session during the regular meeting in the TBT committee under the agenda item on regulatory cooperation. And as well, there'll be a longer moderator's report, which will be circulated in a few weeks. Last, but certainly not least, I'd also like to thank the TBT team and secretariat, who, quite frankly, without this, I would have been lost, being, as Madonna said, a WTO TBT virgin here. And I'd also like to very much thank our interpreters for their hard work and keeping up with some of us who spoke fast. So thank you so much. I do encourage everyone to join my colleague from Singapore, Wei, who will be moderating the next thematic session focusing on cybersecurity. That will start at 1500 Geneva time. This will be an important opportunity to have more focused discussion on regulatory measures that address cybersecurity, a key subset of the regulatory actions we've been discussing in this session. And one last plug, Eddie has been kind enough to leave some copies of her of the National Board of Trade's report out in the hallway. If you'd like a hard copy, I noted you could leave your email address and she would follow up with you. And with that, thank you very much. I conclude this thematic session with 3 minutes to spare. Thank you very much.